And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have your state has to.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck, and I can tell you, she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take, and that she will be able to complete her probation. I'm asking the court to put her on the high medium caseload and see if she does what she says she can do. If she's on her medication, and we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing a community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you're supposed to do the first time.
I got in a car accident, but like I say, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it. And I've been taking my medicine. I've been doing everything that I'm supposed to, and I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
Should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman?
I don't have much to offer, Judge. Saying things and making representations, they're easy to do and easy to say, but it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindletop to get those mental health, mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her, and she may have a better chance.
So I'm looking back at the original pre-sentence report from 2024.
Mm-hmm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, I mean, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Miss Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. Going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't. So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with Spindletop, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, ma'am.
So this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need because you'll be given that opportunity. Okay.
Yes, ma'am.
All right. Good luck to you.
Thanks, Judge.
Thank you. Good morning. Are you Micah Powell?
Yes, ma'am, I am. Good morning.
And this is cause number 25 DCCR 1522. Mr. Powell is charged with burglary of a habitation. Mr. Minaldi is here on behalf of Mr. Galmore, who filed an application for writ seeking reasonable bail. Looks like the bond is currently set at $50,000. Ms. Minaldi, you may proceed.
Judge, just based off of Mr. Galmore's request, it's clear that with his family having an interest in his case and supporting him in that case, he would be here for court settings if he were to be released on bond. He does have the proper means to get to his attorney's office. He does have the proper means to get him to court. He has motivation to show up and handle these cases. He's not a flight risk. He's not at risk of not showing up in that capacity. We're just requesting that he have a bond set that he can afford. I believe Mr. Galmore has requested it be decreased to $5,000 so that he can afford it. It's clear that he cannot afford the current amount of
Let's
$50,000.
put some evidence on with regard to that. Raise your right hand, please, sir, the best you can. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. Go ahead.
Do you have access to any type of savings accounts in your name?
Yes, I have 2 different bank accounts.
Okay, where are those bank accounts?
Ready Financial and there's a credit union out of Galveston. Can't remember the exact name of it.
And- About how much do you have in those accounts?
About maybe 901, and the other one was probably maybe I had one of them was for withdrawals.
estimation.
Probably about 1,400 total.
Okay, and are you employed currently?
Due to my incarceration, I am no longer employed, but I do have somebody willing to take a chance on me and give me a very good job opportunity for release.
Okay, and is that job located in Jefferson County?
It would be over in Pasadena.
But
But I drive. I can
Okay.
drive back.
you would
and
be
forth.
able to come into your court settings?
I'm looking to get this settled because I cannot go on my life with this over my head.
And then do you have any type of cash or any money outside of those savings accounts that you mentioned?
I do hand over fist fish and guide services for anybody who requested to give me supplemental income.
But do you have any actual physical cash that is supplement to those savings accounts that you mentioned?
No, I'm not currently.
Okay. Do you have any assets, stocks, bonds, or anything like that that you could access to help make the current bond? And then do you own any real property?
Any questions?
There's not argument.
All right, go ahead, Ms. Malfino.
Judge, I would respectfully object to the bond being reduced, especially to amount of $5,000 for a habitual offender who has prior burglaries for which he has served pen time. This will be a pen time offer. In this case, I believe the offer extended by Mr. Smith actually went below the minimum 25 of his habitual status, but we don't think that any bond lower than 50,000 is justified, judge, based on his criminal history, and would ask the court to take all of that into consideration.
So I am going to take judicial note of the court's file. Need a drink? You good? Including, obviously the indictment itself that alleges, prior convictions, burglary of a habitation, second degree felony from the year 2000, two different ones from that same year, an evading arrest or detention, third degree from 2007, another burglary of a habitation, a second degree from 2018. Looks like all of those, well, we've got Galveston County, Tyler County, and Harris County alleged, and Jefferson County. So I also have reviewed the probable cause affidavit in this case, and the allegations in this case looks like, at least according to this, that the allegations are that Mr. Powell was actually trespass warned from the owner of the house's job, that there was some type of harassment in the past or some relationship that caused some issues where he was actually trespass warned from a job location, and that there is apparently video footage of this offense as well. Based on all of that and the fact that he would be considered a habitual offender, with this being his fourth allegation of burglary of a habitation, if anything, that bond, in my opinion, is low. Based on all of that, I'm going to deny the writ and find that, or the request based in that writ, and find that the current bond is sufficient, I guess. I don't really think it is, in fact, but I'm going to keep it at least the same for now. All right. And we'll reset it for an announcement. You can go back with the bailiff.
Thank you. Maybe excuse.
Yes, ma'am. Thank you. Right, so are you Dalton Batiste? And this is cause number 25 DCCR 1436. Mr. Batiste is charged with manslaughter. 25 DCCR 1437 charged with manslaughter, and 24 DCCR 0407 charged with possession of marijuana. The cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Couple issues, if I may, Judge. Mr. Coleman and I have talked extensively, not only this morning, but in the last lead up to today, and there has been a new proposal put in front of us that I think we'd like to ask for at least a little bit longer than today to consider. I know that also Mr. Coleman has responsibilities to folks on his side to discuss it or fight this. Sorry, Ian.
Take a break. Why is this one? This one's not showing up on my. What is it? It's not on my.
Actually, I was just trying to see attorney, he was being very difficult. But now it says Tom Kelly, so that's why
Oh,
because I had changed their co-counsel and he was trying, I thought he was signing them up.
okay.
Couldn't walk the
Sorry.
tablet.
And then
You okay? You need some water?
I've got.
you want cough drop?
Oh, I do have that.
I think the sinuses.
Yeah. Yeah.
No, it's fine. Well, okay, so here's the thing. There's only 2 defendants left on the trial docket for next week. So I need to know something today.
My other issue, Mr. Gertz asked me to say this. He is set in Judge Templeton's court
Oh,
on a case, Austin
Yes,
Jones.
especially if
Been
that,
tried previously too.
And that's next week.
That's next week.
Yeah, I'm not sure that I should have taken that into consideration. So obviously that is a specially set case for Mr. Gertz over there. And we've done a protection order for him to get that case taken care of since it's an injury to a
I
child.
understood, Judge. I think we're very close to resolving this case. Still notwithstanding the other case, I
Okay.
still would like to try to push this case to get resolved.
Sure. So here's what I'm
Like to
gonna
talk about
do.
victims.
So what I'm gonna do is just for a short time, take it off the trial docket, place it on a review in about 3 weeks. That gives you and Mr. Gertz time to visit with Mr. Batiste, Mr. Coleman time to visit with anybody he needs to visit with. And then if something gets worked out, we'll take care of it at that time in 3 weeks. If not, it'll go right back on the trial docket and we'll go from there.
Understood.
Sound good?
Yes, Judge.
Okay, you can go back with the bailiff.
Thank you. Thank you.
Are you Darius Derry?
Yes, no.
And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Derry, in cause number 26 DCCR 0234, you're charged with the state jail felony offense of burglary of a building from December 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Derry is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 100 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. Kevin Thomas.
And just like that, the courtroom moves on to the next case. One defendant watched his bond conditions get dramatically tougher, another accepted responsibility and received his sentence, and a third chose to roll the dice and head toward trial. Courtrooms can change lives in a matter of minutes, and today's hearing was a perfect example of that.